The room didn't erupt. No gasps. No shouting. Just a pause. The kind that makes lawyers stop mid-note and judges look up instead of down. That's how this moment began. Because for all the noise that surrounds royalty, for all the commentary and headlines and opinion masquerading as certainty, the most dangerous moments don't announce themselves. They arrive quietly, almost politely, and by the time everyone realizes what just happened, it's already on the record. This week, inside the High Court in London, something like that happened again, and it involved Prince Harry. At first glance, this was supposed to be familiar territory, another legal appearance, another chapter in a long-running war between the Duke of Sussex and the British press, another day of testimony about intrusion, privacy, and the scars left behind by tabloids that never forgot his name. But that assumption, that this was just another round, didn't survive long. Because this time, Harry wasn't just facing editors or publishers. He was facing his own words. Not angry words. Not headlines. Words spoken years ago, calmly, confidently, repeated often enough that they became part of the public story. And now, placed beside sworn testimony, those words started to look different. This is where stories like this usually lose people. They turn technical, legal, abstract. You're told to care about dates and documents and definitions. But strip this down, and what's unfolding isn't abstract at all. It's personal. It's human. And for the royal family, it may be something far more dangerous than another lawsuit. Because when a royal's public narrative collides with the courtroom record, the consequences don't stay in the courtroom. They ripple outward. This is not a video about tabloids behaving badly, although that question remains at the center of the lawsuit. And it's not a video about whether Prince Harry is right or wrong to challenge the press. That debate has been raging for years, and reasonable people still land on different sides. This is a video about what happens when the story you've told the world is suddenly weighed against the story you're legally required to tell under oath. And what happens when those stories don't line up perfectly. The Duke of Sussex returned to London's High Court as part of his lawsuit against Associated Newspapers, the publisher of the Daily Mail and the Mail on Sunday. He alleges that the publisher illegally gathered private information, a claim the company has vigorously denied. This is not new ground. Similar accusations have surfaced in other cases. Similar defenses have been mounted. What is new is the timing. What is new is the intensity. And what is new is the scrutiny. Not just of the press, but of Harry himself. Because when you step into a witness box, you don't just repeat your story. You submit it to examination. And that changes everything. Inside High Court of Justice, words behave differently. They don't float. They don't inspire. They don't trend. They lock into place. They're tested for consistency, not emotion. Precision matters more than passion. That's not always comfortable for someone who has spent years telling his story in interviews, speeches, and a memoir that encouraged readers to feel alongside him. In those settings, emotion isn't a liability, it's the point. In court, emotion is background noise. And this week, the questions stopped sounding like invitations and started sounding like measurements. When exactly did you know? How did you learn this information? What proof did you rely on at the time? Did you say this before? Or after? These are not hostile questions. They don't accuse. They don't shout. But they do something else. They narrow the space between memory and record until only one version can fit. And that's where things grew complicated. Because over the years, Prince Harry has spoken openly about his belief that the British press intruded into his life, that they listened when they shouldn't have, followed when they had no right to, and helped shape events that left lasting harm. Those claims weren't whispered. They were broadcast, repeated, incorporated into a broader narrative about distrust, trauma, and the price of growing up royal. That narrative became familiar to the public, familiar enough that many stopped questioning its details, familiar enough that it hardened into something that felt settled. But settled stories behave differently when they're unsettled. And that's what happened in court. Not all at once. Not dramatically. No moment where someone shouted contradiction and slammed a document onto the desk. Instead, it unfolded the way these things often do, slowly, incrementally, almost politely. A question here, a pause there, a clarification that didn't quite clarify. At one point, Harry acknowledged that some claims he once believed to be the result of illegal information gathering were, in fact, assumptions. Not conclusions reached through evidence. but suspicions formed over time. Understandable suspicions, perhaps, but suspicions nonetheless. That distinction matters more than most people realize. Because suspicion is allowed in interviews. Belief is allowed in memoirs. But in court, what matters is what you can show, not what you felt. And when those two worlds collide, the fallout doesn't just affect the witness. It affects everyone connected to them. Which brings us to the part of this story that hasn't been said out loud. Not in court, not in headlines, and not officially. The monarchy has been watching. Not publicly, not with statements or press briefings, but attentively, carefully, because while this lawsuit is Harry's, the implications don't belong to him alone. Every sworn word spoken by a senior royal carries institutional weight, even when that royal has stepped back, even when titles are no longer used in the same way, even when relationships are strained. Because the public doesn't separate individuals from institutions as neatly as lawyers do. And this is where King Charles III enters the picture, not as a courtroom participant, but as a presence that cannot be ignored. Charles did not bring this lawsuit. Charles did not sit in the witness box. Charles did not testify. But Charles carries responsibility for the stability, credibility, and perceived integrity of the crown. And that creates a quiet tension. One that grows sharper when testimony raises questions not just about publishers, but about truth. To be clear, no court has accused Prince Harry of lying. No judge has made such a finding. That's not how these things happen, and it's not what this moment is about. This moment is about contradictions, about differences between past statements and present testimony, about what happens when confidence meets cross-examination, and about how institutions respond when those differences become visible. There is a reason the palace has been silent for so long. Silence can be protective. It can allow disputes to burn themselves out. It can signal restraint. But silence can also be strategic, a way of waiting until the facts settle before deciding what must be done. And this week, as testimony continued, something changed. Not in a press release, not in a speech, but in the way legal observers began to talk. Because when sworn testimony creates ambiguity instead of clarity, lawyers don't ask whether a story is compelling. They ask whether it's sustainable. And somewhere between the second and third day of testimony, that question stopped being hypothetical. This is where we need to slow down, because the instinct right now is to rush to conclusions, to decide who's right, to decide who's wrong, to declare victory or failure. But the most consequential developments in stories like this rarely announce themselves so cleanly. They surface as unease, as recalculations, as phone calls that don't show up on any docket. Because when legal risk intersects with family, the calculations change again. Imagine, for a moment, being a monarch watching your son testify, not emotionally, but institutionally. Watching as years of public narrative are placed beside sworn answers. Watching as lawyers do what lawyers do. Test, probe, measure. What would you do if you believe the integrity of the crown might be pulled into a legal narrative you don't control? Would you speak? Would you wait? Or would you quietly prepare? This is not a story about punishment. It's not a story about revenge. It's a story about boundaries. Because there is one boundary the monarchy cannot afford to blur, and that is the line between personal grievance and institutional credibility. And that line was brushed this week. Not crossed, brushed. Enough to notice, enough to take note, enough that legal eyes started shifting, not toward the press, but toward potential consequences elsewhere. There is a phrase that surfaced quietly in conversations surrounding this case. Not quoted, not attributed, just mentioned in passing. I am calling my lawyer. Not said in anger, not said publicly, but said seriously. And when that phrase enters a royal context, it doesn't signal drama. It signals preparation. Because once lawyers become involved at that level, the story is no longer just about what happened in the past. It's about what might happen next. And that's where this case is heading, whether anyone wants it to or not. Because what began as a lawsuit against the press is slowly becoming something else entirely. Something more delicate, more dangerous, and far harder to contain. But the moment that truly changed everything didn't happen on camera. It didn't happen in the headlines. It happened when a seemingly small contradiction sat unanswered, just long enough for everyone in the room to realize it couldn't be ignored. And that realization set off a chain of events that is still unfolding. What came next would shift the legal focus, strain already fragile family lines, and force the monarchy to consider options it has avoided for years. And no one in that courtroom, not even the people asking the questions, fully understood what they had just triggered. The lawsuit was supposed to be simple. That's what everyone thought at the beginning. Journalists, lawyers, even seasoned court watchers who have followed royal litigation for decades. On paper, it looked familiar. Another high-profile challenge. Another clash between a royal and the British press. Another chance to revisit the long, bitter history between Prince Harry and the tabloids that chronicled his life before he ever had a say in it. But simple cases don't usually feel like this. Simple cases don't make seasoned barristers pause mid-question. They don't cause reporters to quietly compare notes during breaks. And they don't generate that particular kind of tension, the kind that doesn't come from fireworks, but from uncertainty. Because this case, almost immediately, stopped behaving the way it was supposed to. The lawsuit centers on allegations that Associated newspapers illegally gathered private information about Prince Harry over a number of years. The claims are serious. They include accusations of phone hacking, the use of private investigators, and other intrusive methods that, if proven, would represent clear violations of privacy and the law. Associated Newspapers has vigorously denied those allegations. Publicly, firmly, without hedging. Their position is that the claims are either unfounded, exaggerated, or based on assumptions rather than evidence. This is the kind of legal standoff the British courts have seen before. In fact, similar cases involving other public figures have played out with predictable rhythms: accusations, denials, evidence disputes, settlements, or judgments. There is a well-worn legal path for this type of conflict, which is exactly why so many people expected this case to follow it. Instead, it veered. From the moment Prince Harry returned to London and stepped into the High Court, the atmosphere felt heavier. Not hostile, not dramatic, just weighted. As if everyone present understood that this was no longer just a dispute about journalistic conduct. This was about credibility. And credibility, in court, is a fragile thing. Inside the High Court of Justice, cases don't unfold like stories. There is no narrator guiding the audience. No emotional soundtrack. Just questions, answers, and the quiet discipline of legal procedure. It's an environment that rewards precision and punishes assumption. That matters, because Prince Harry's relationship with this issue has always been deeply personal. He has spoken, often and openly, about how press intrusion shaped his childhood, affected his mental health, and influenced decisions that would ultimately alter the course of his life. Those experiences form the emotional backbone of his public narrative. But courtrooms don't deal in emotional backbones. They deal in facts. And this case forced a collision between the two. At first, the proceedings moved as expected. Lawyers laid out the scope of the allegations. Timelines were referenced. Legal frameworks were explained. Harry answered questions calmly, thoughtfully, sometimes with visible effort to be precise. There was no drama, no confrontation, no raised voices. And yet, something was off. Because beneath the surface, the case wasn't just asking whether journalists broke the law. It was asking how Harry knew what he claimed to know, and when. That distinction is subtle, but critical. In interviews and public statements over the years, Harry has often spoken with certainty about press misconduct. Certainty that resonated with audiences who were already inclined to believe the worst about tabloid behavior. Certainty that felt earned by experience, if not by evidence. In court, certainty has to be justified. Not emotionally, not morally, legally. And the questions began to narrow. When did you become aware of this information? What led you to that belief? Was this conclusion based on direct evidence or inference? These are not accusatory questions. They are routine, but they do something powerful. They separate belief from proof. At one point, Harry acknowledged that he had not personally seen evidence of certain alleged activities at the time he believed they occurred. Instead, he described patterns, suspicions, and conclusions drawn over years of media exposure. Again, that admission was not explosive. It didn't sound reckless or evasive. It sounded human. But human answers don't always align with legal standards. And that's where the case began to drift away from its original frame. Because if parts of the claim rely on inference rather than demonstrable evidence, the court must treat them differently. That doesn't mean the claims are false. It means they require stronger corroboration. And as that reality set in, the courtroom dynamic shifted. Lawyers began to revisit earlier statements. Not aggressively, methodically, they referenced interviews, articles, public comments made long before this case reached trial. Not to embarrass, but to contextualize. And context can be dangerous, because context reveals patterns of language, patterns of certainty, patterns of belief. And sometimes, those patterns don't align neatly with sworn testimony. This is where the idea of contradiction first entered the conversation, not as an accusation, but as a question mark. Was this claim always this specific? Was this belief always this certain? Or had the narrative evolved over time? That question matters more than it seems. Because in the court of public opinion, evolving narratives are expected. People grow, they learn, they reinterpret their past. That's normal. In court, evolving narratives raise eyebrows. Not because evolution is suspicious, but because inconsistency can weaken a case. And this case, despite its apparent simplicity, began to show signs of strain. Observers noted that Harry frequently emphasized how intrusive the press felt, how relentless the coverage was, how impossible it seemed to escape scrutiny. All of that rang true to those familiar with royal media culture. But when pressed on specifics, on how particular pieces of information were obtained, the answers grew less concrete. Sometimes the response was, "I believe." Sometimes it felt obvious. Sometimes it was, given the timing, it seemed likely. Those phrases are powerful in personal storytelling. They are less powerful under oath. This doesn't mean Harry was dishonest. That conclusion would be premature and unfair. What it does mean is that the case began to hinge on interpretation rather than demonstration. And interpretation is a fragile foundation for litigation. The press coverage outside the courtroom, interestingly, lagged behind this shift. Headlines focused on familiar angles: Harry versus the tabloids, privacy versus intrusion, royalty versus press freedom. Those narratives were comfortable. They fit expectations. But inside the courtroom, the emphasis was changing. Lawyers weren't asking, "Did this hurt you?" They were asking, "How do you know this happened?" That distinction might seem technical, but it's everything. Because courts don't exist to validate feelings. They exist to establish facts. And once that line becomes the focus, cases that seem straightforward can become unpredictable. This unpredictability began to ripple outward. Legal commentators started using cautious language. Phrases like potential weakness and evidentiary challenges crept into analysis. No one declared a turning point, but no one denied the tension either. And then there was the matter of timing. The lawsuit didn't emerge in a vacuum. It arrived after years of public storytelling, after a memoir, after high-profile interviews that reached global audiences. That history doesn't invalidate the case, but it does complicate it. Because when a witness has already told their story many times, the court inevitably asks whether the version presented under oath aligns with those earlier accounts. And alignment, in this case, was not perfect. Small differences, subtle shifts, enough to notice, not enough to resolve. And that unresolved space is where legal trouble lives. This is the point where many expected the case to correct itself, for evidence to emerge that would decisively support Harry's claims, or for the defense to falter under scrutiny. That's how these stories usually go. But instead, the case slowed. Questions became narrower. Answers became more careful. The room grew quieter. Because everyone involved could sense that the lawsuit was no longer just about proving wrongdoing. It was about navigating ambiguity. And ambiguity is dangerous in court. More dangerous still when the witness is a prince. Because while this lawsuit belongs to Harry, its implications don't belong to him alone. Every answer given under oath exists within a broader context, one shaped by monarchy, tradition, and public trust. And that context does not forgive easily. As the first phase of testimony concluded, there was no dramatic moment to point to. No gasp. No headline-ready exchange. Just a lingering question that refused to settle. Was this case as solid as it first appeared? Or had something shifted beneath the surface? Something that would change how the court, the press, and the palace viewed what came next? Because once doubt enters a legal narrative, it rarely stays contained. And the next phase of questioning would test whether that doubt was incidental or structural. What followed would force everyone involved to look backward. Not at the tabloids, but at the record itself. And that is where the real danger began. So here's the question that quietly took over the room. And records don't care how a story feels. They care how it holds. Sworn testimony is a strange thing. People talk about it as if it's just telling the truth, but that's not quite right. It's narrower than that. More exacting. You're not asked to give your truth. You're asked to give the truth in a form that can be tested, challenged, and, if necessary, dismantled. That's why witnesses often sound different under oath. Not less sincere, just more careful, sometimes more hesitant, sometimes slower. That change was noticeable. Harry didn't enter the courtroom defensive. If anything, he seemed determined to be precise. There was a conscious effort to answer what was asked, not what he might have said in another context, not what he had said in interviews years earlier, but what he could say now, under oath. And that discipline mattered. Because the questions were no longer about impact or harm. They were about knowledge. What did you know? When did you know it? And how did you come to know it? Those questions sound simple. They almost are. But they carry weight because they force a separation most public storytelling avoids. The separation between belief and proof. For years, Harry's public narrative blurred that line. Understandably, even convincingly. The sense that the press had access to information it shouldn't have had. The feeling that private moments became public too easily. The conviction that something illicit must have been happening behind the scenes. In everyday conversation, that reasoning makes sense. In a courtroom, it gets examined. One answer in particular landed differently than expected. Harry acknowledged that, at the time certain articles were published, he did not have direct evidence of illegal information gathering. His belief was based on patterns he observed, timing that seemed suspicious, and information that later came to light in unrelated cases. That distinction is subtle, but subtlety is where cases are won and lost. Because belief formed after the fact doesn't always justify certainty expressed before it. No one in the courtroom accused Harry of fabricating anything. That's important. The tone remained professional, restrained. But restraint doesn't mean neutrality. It means patience. And patience is dangerous when contradictions are still forming. As the questioning continued, lawyers began to map Harry's earlier public statements against his current testimony. Not in a confrontational way, more like an audit. Dates were compared. Language was scrutinized. The evolution of certain claims was traced. It wasn't about catching him out. It was about understanding whether the story had remained consistent. And this is where things grew uncomfortable. Not dramatically, but persistently. Some earlier statements were broad, confident, declarative. In court, those same claims became qualified, contextual, conditional. Again, that's human. People refine their understanding over time. But courts don't evaluate humanity. They evaluate reliability. And reliability depends on stability. At one point, Harry used the phrase, "I believe," repeatedly in response to questions about how information was obtained. It wasn't evasive. It wasn't flippant. It sounded honest. But honesty and sufficiency are not the same thing. I believe does not establish method. I felt does not establish causation. I assumed does not establish proof. This is where sworn testimony becomes unforgiving. It strips away narrative momentum and leaves only structure behind. And when structure is weak, it shows. The atmosphere in the room shifted again, not in a way you could point to on camera. There was no visible tension between counsel, no dramatic objections. But something else happened. The pace slowed. Questions became more granular. Answers became more cautious. It was as if everyone realized the case had entered a different phase, one where assumptions would be interrogated as closely as actions. Legal observers began to exchange glances, quiet ones, the kind that signal recognition rather than surprise. Because this wasn't about one answer. It was about accumulation. One qualified statement doesn't matter much. 2 invite curiosity. 3 create a pattern. And patterns, in court, don't go unnoticed. What made this particularly delicate is Harry's unique position. He is not a typical claimant. His life has been documented extensively since childhood. His relationship with the press is not abstract. It's deeply personal, deeply documented, and deeply emotional. That history cuts both ways. On one hand, it explains why he might reasonably assume wrongdoing. On the other, it complicates efforts to distinguish between intrusion and inference. The court is not there to adjudicate trauma. It's there to adjudicate actions. And actions require evidence. As testimony continued, the line between what Harry experienced and what he could prove became increasingly important. Not because his experiences were dismissed, they weren't, but because experience alone does not establish a legality. This is where the concept of contradiction begins to matter. Not as an accusation, but as a tension. If a public statement once suggested certainty, and sworn testimony now suggests uncertainty, the court has to ask why. Did the understanding change? Did new information emerge? Or was the earlier certainty overstated? Those are uncomfortable questions for any witness. They are particularly uncomfortable for someone whose credibility extends beyond the case at hand. Because Harry's words don't just affect his lawsuit. They shape public perception of the monarchy, of the press, and of truth itself. And that broader impact was quietly hanging over the proceedings. You could sense it in the way questions were framed. Careful not to inflame, careful not to accuse, but also careful not to gloss over inconsistencies. This was not an ambush. It was a calibration. How much weight can this testimony carry? That's the question courts ask when credibility becomes central. And it's the question that began to ripple outward. Commentary outside the courtroom grew more cautious. Analysts stopped predicting outcomes. Language softened. Phrases like could complicate matters and raises evidentiary challenges replaced confident declarations. No one was declaring collapse, but no one was declaring victory either. And then there was the silence from the palace. That silence has been interpreted in many ways over the years. As indifference, as restraint, as quiet support, as strategic distance. In this context, it took on a different quality, because silence can be a form of observation. And when testimony introduces uncertainty, observers don't rush to speak. They wait. Inside the courtroom, the judge listened, took notes, asked few questions. Judges rarely signal what they're thinking, especially in cases like this, but attention itself is a signal. And Harry, to his credit, did not retreat. He didn't attempt to embellish. If anything, he leaned further into caution. He clarified when unsure. He corrected himself when necessary. He acknowledged gaps in his knowledge. Those moments might play well with some audiences. They suggest sincerity. They suggest humility. But sincerity does not automatically translate to legal strength. This is the paradox of sworn testimony. The more honest you are about uncertainty, the more exposed your case can become. And that exposure was beginning to show. The courtroom didn't react with shock. It reacted with focus. The kind of focus that suggests a recalibration is underway. What had been framed as a battle over press misconduct was quietly becoming an examination of narrative consistency. And that shift carries consequences. Because once a case pivots toward credibility, it invites scrutiny far beyond the original allegations. Past interviews, past statements, past assumptions. Everything becomes relevant. This is the moment many observers later identified as the turning point. Not because something definitive happened, but because the direction changed. The case was no longer moving toward resolution. It was moving toward examination. An examination doesn't end where you expect it to, especially when the witness is a prince. Because every word spoken under oath exists not just in the context of a lawsuit, but in the shadow of an institution that depends on trust. That's where the stakes quietly expanded. What happens if sworn testimony casts doubt on parts of a long-standing public narrative? Not enough to accuse, but enough to question? Does the institution respond? Does it distance itself? Does it prepare? Those questions weren't asked in court. They didn't need to be. They were being asked elsewhere. By lawyers who don't speak publicly. By advisors who don't brief reporters. By people whose job is to anticipate risk, not react to headlines. And when those people begin to ask questions, things start moving. Slowly, quietly, but decisively. The testimony continued. The answers remained measured. No explosion. No collapse. But something had been set in motion. A realization that this case was no longer just about what the press may have done, but about what could now be done in response. Because credibility, once questioned, doesn't stay questioned in isolation. It spreads. And the next phase of this story would not be driven by emotion or history, but by strategy. What came next would involve a different kind of preparation, one that doesn't happen in open court, and doesn't announce itself with a headline. It happens behind closed doors, when people realize the risks are no longer theoretical, and that realization was already taking shape. Here's the uncomfortable pivot nobody in that courtroom could avoid. What happens when the record starts talking back? Because once sworn testimony is on the table, the past doesn't stay in the past. It becomes active. It gets reopened, reread, reinterpreted, not through memory, but through documentation. And documentation is relentless. This is where the case began pulling threads that had been neatly tucked away for years. Not aggressively, not publicly, but methodically. The court didn't need to introduce anything new. It didn't need secret evidence or dramatic revelations. All it had to do was place Prince Harry's sworn words beside statements he had already made, many times, to many audiences, across many platforms, and then let the contrast sit there. That contrast didn't scream. It whispered. Because when you hear a story once, you absorb it emotionally. When you hear it twice, you recognize it. When you hear it a third time, and the wording shifts, your brain starts doing something else entirely. It starts comparing. That's what the court does by default. Over the years, Prince Harry has spoken openly about his belief that the British press obtained private information illegally. He didn't present those beliefs tentatively. He spoke with certainty, with conviction, often with a sense that the facts were already settled, even if the legal processes were not. Those statements shaped public understanding. They weren't buried. They were front and center. In interviews, speeches, and a memoir that framed his experiences as part of a larger, coherent narrative of intrusion and betrayal. That narrative wasn't just personal. It was persuasive. But persuasion and proof operate on different rules. In court, lawyers don't ask whether a story is compelling. They ask whether it's consistent. And consistency doesn't mean identical wording. It means alignment and substance. This is where the first real discomfort surfaced. Earlier public statements often implied direct knowledge, not necessarily first-hand observation, but a confidence that suggested information had been obtained through specific illicit means. In sworn testimony, that confidence softened, not disappeared, softened. The language shifted toward belief rather than knowledge, toward inference rather than confirmation, toward suspicion informed by context rather than evidence available at the time. Again, that shift makes sense from a human perspective. People don't always distinguish between what they know and what they believe when speaking publicly, especially about deeply personal experiences. But courts draw that distinction ruthlessly. And once it's drawn, everything changes. Because the court isn't asking, did this feel invasive? It's asking, can you show how this happened? Those are not the same question. This chapter of the case wasn't about attacking Harry's credibility. It was about defining it. What weight should be given to statements that were once made with certainty, but are now presented with caveats? That question hung in the air, unspoken but unavoidable. Lawyers began referencing past interviews carefully, not quoting for effect, but for comparison. They weren't accusing Harry of exaggeration. They were asking him to explain evolution. Why did this sound more certain then than it does now? What changed between that statement and this testimony? Was new information introduced, or was the earlier certainty overstated? Those questions aren't traps. They're tests. And tests don't need dramatic answers to be effective. At times, Harry acknowledged that his earlier understanding had been shaped by later revelations in unrelated cases involving press misconduct. In other words, knowledge gained after the fact influenced how he interpreted earlier events. That explanation is logical. It's also legally complicated. Because courts are cautious about retroactive certainty. If belief is formed after evidence emerges elsewhere, it doesn't automatically validate certainty expressed before that evidence existed. That's not a moral judgment. It's a legal one. This is where the idea of contradiction needs to be handled carefully. Contradiction doesn't necessarily mean falsehood. It means misalignment. And misalignment raises questions, not about intent, but about reliability. The public often assumes courts are hunting for lies. They're not. Courts are hunting for coherence. And coherence was becoming harder to establish. Some statements Harry had made publicly were broad enough to absorb reinterpretation. Others were more specific, tied to timing, methods, or sources. It was those specific claims that drew the most attention, not because they were dramatic, but because specificity limits flexibility. When you say this must have happened, and later say, I believe this happened, the difference matters. It matters because the court must decide whether claims are grounded in demonstrable fact or inferred narrative. An inferred narrative is fragile. As this process unfolded, the room remained quiet. No one appeared triumphant. No one looked defeated. This wasn't that kind of moment. Instead, it felt like the ground was slowly being surveyed. What holds? What doesn't? What needs reinforcement? Observers later described it as watching a structure being stress-tested, not collapsing, but revealing where reinforcement might be needed. And reinforcement, in legal terms, often means corroboration, which raised an obvious question. Where would that corroboration come from? Harry's testimony leaned heavily on patterns, repeated experiences that suggested something systemic. That approach resonates emotionally, especially given the history of tabloid behavior toward the royal family. But courts don't establish a legality through pattern alone. They require linkage. Linkage between action and method, between outcome and cause, between suspicion and proof. And in several instances, that linkage was implied rather than established. Again, implied does not mean incorrect. It means incomplete, and incomplete stories don't end neatly. The significance of this shift cannot be overstated, because once the court begins weighing the reliability of a witness's broader narrative, it doesn't isolate that assessment to one case. Credibility is cumulative. If a witness is found to rely heavily on inference, courts adjust how much weight they give to those inferences going forward. That doesn't invalidate the witness, it contextualizes them, and context shapes outcomes. This is why legal observers began to talk less about the alleged actions of the press, and more about the structure of Harry's case. Was it built to withstand this level of scrutiny? Or was it designed for a different arena, one where emotional truth carries more weight than evidentiary rigor? That's not a criticism. It's an observation. Public storytelling and legal argument serve different purposes. They follow different rules. And when they overlap, tension is inevitable. That tension was now visible. And visible tension invites consequence. Not immediately, not publicly, but internally. Because while the courtroom focused on testimony, others were watching the broader implications unfold. The monarchy, for one, is acutely sensitive to questions of narrative consistency, not because it fears truth, but because it depends on trust. Trust that what is said publicly aligns with what can be defended privately. Trust that personal grievances do not become institutional vulnerabilities. This is where the case subtly expanded beyond Harry. Not in any formal sense, not in any stated way, but in implication. Because if sworn testimony reveals that a senior royal's public narrative was built, in part, on assumptions later reframed as belief, that raises uncomfortable questions. Not about wrongdoing, but about judgment. And judgment matters when you represent something larger than yourself. The court did not need to say any of this out loud. The implications were clear enough. As the questioning moved forward, there was a noticeable shift in how carefully Harry framed his answers. He avoided declarative language. He emphasized uncertainty where appropriate. He corrected himself when he felt a statement might overreach. Those corrections might be read as integrity. They might also be read as recalibration. Both interpretations can be true. But recalibration mid-testimony signals awareness. Awareness that earlier certainty might not hold. And that awareness, once demonstrated, cannot be unseen. This is the point where the case stopped being about proving misconduct and started being about managing exposure. Exposure to doubt. Exposure to reinterpretation. Exposure to consequences that extend beyond a single lawsuit. Because the moment sworn testimony diverges from earlier public claims, even subtly, it creates space for others to act. Not the press, not commentators, but advisors, lawyers, strategists, people whose job is to ask, what if this doesn't stop here? And that's where the quiet conversations begin, not about winning or losing, but about containment. Because in institutional settings, containment is often more important than resolution. In this case, once framed as a challenge to press behavior, was now touching something more sensitive, the stability of narrative. And when narrative stability is threatened, institutions respond, not emotionally, but structurally. The courtroom continued its work. The testimony continued. Nothing exploded. But beneath the surface, something fundamental had changed. The past was no longer a supporting character. It was now a witness. And witnesses, once called, cannot be dismissed. What followed would not involve louder questions, but deeper ones. Questions that don't get asked in open court. Questions that don't make headlines. Questions that reshape decisions long before the public notices. Because once the record starts talking back, the story is no longer yours to control. And the next contradiction, the one no. That discomfort was palpable, not as distress, but as recalibration. Harry wasn't being cornered. He was being narrowed. Narrowed toward what he could say with certainty. Narrowed away from what he once said with conviction. Those are not the same thing. And that difference matters because it reveals something deeper about this case. It was never just about what happened. It was about how meaning was constructed. Meaning constructed in public forums tends to be expansive. It connects dots. It tells a coherent story. It prioritizes emotional truth. Meaning constructed in court is reductive. It isolates claims. It demands justification. It prioritizes verifiability. When those two systems collide, something gives. In this case, it wasn't emotion. It was narrative. And that's why this first contradiction mattered so much. Not because it disproved anything, but because it destabilized the foundation. Once that foundation wobbles, even slightly, every subsequent claim is reassessed through that lens. Is this another belief formed later? Is this another conclusion drawn retrospectively? Is this another certainty that didn't exist at the time? Those questions don't accuse. They accumulate. And accumulation is dangerous. Because the longer this line of inquiry continued, the harder it became to return to the original framing of the case. The press was no longer the sole subject. The narrative itself was now under examination. This is where the broader implications began to surface, not explicitly, but inevitably. If a senior royal's public narrative is shown to rely heavily on retrospective certainty, what does that mean for the institution's relationship with truth? Not truth as an abstract ideal, but truth as a standard applied under oath. The monarchy does not function on legal certainty alone. It functions on trust. On the assumption that what is said publicly can withstand scrutiny privately. That assumption was being tested, not shattered, but tested. And tests prompt preparation. This is the point where attention quietly shifted beyond the courtroom, where advisors, not participants, began to take notes. Because the risk here wasn't just losing a case. It was opening a door to reinterpretation, a door to challenge, a door to questions that extend far beyond tabloids. And once doors like that open, they rarely close cleanly. The judge did not intervene. The lawyers did not escalate. The day ended without fireworks. But the contradiction remained. Unresolved, unexplained, sitting in the record. And records have a way of resurfacing when it matters most. As proceedings adjourned, there was a noticeable quiet. Not relief, not tension, but something closer to contemplation. Because everyone involved understood that the case had crossed an invisible threshold. The narrative was no longer protected by familiarity. It was now subject to analysis. An analysis, once begun, does not stop where you want it to. The next phase of questioning would build on this foundation, not to accuse, but to explore. And exploration, in legal terms, often leads to places no one originally intended to go. Because the most dangerous contradictions are not the loud ones. They're the quiet ones that force everyone to rethink what they thought they already understood. And that rethinking was only just beginning to here's where the case stopped being about what anyone remembered and started being about what memory could legally sustain. Because memory, in a courtroom, is not treated as a sacred thing. It's treated as evidence. Fallible, influenced, subject to time, emotion, repetition, and reinforcement. Judges know this. Lawyers rely on it. And witnesses, whether they like it or not, are measured against it. That reality settled in quietly as questioning resumed. Not with a confrontation, not with a challenge, but with a change in framing. The questions no longer circled around events. They circled around recollection. How certain are you about this? Is this something you remembered directly, or something you later came to believe? Can you distinguish between what you knew then and what you understand now? Those are not trick questions. They are foundational. And they matter because the law treats memory differently depending on how it's formed. There is direct recollection, what you personally experienced, observed, or verified at the time. And then there is reconstructed understanding, what you later inferred, learned, or came to accept as true after additional information emerged. Both are human. Only one is legally reliable on its own. This is where things grew genuinely delicate for Prince Harry. Because his story, as he has told it publicly for years, relies heavily on the idea that his lived experience gave him insight others didn't have. That growing up inside the royal bubble made patterns visible to him. Patterns of intrusion, of leaks, of surveillance. That perspective has power. It explains a lot. It resonates emotionally. But when asked to separate what he personally knew at the time from what he later understood, the distinction became harder to maintain. At several points, Harry acknowledged that his understanding of press behavior was influenced by later revelations, by other hacking cases, by settlements involving other claimants, by reporting that emerged years after the events in question. Again, this is not unreasonable. Most people reinterpret their past once new information becomes available. That's how learning works. The problem is that courts do not allow retroactive certainty to substitute for contemporaneous proof. And that's the moment when memory becomes a legal risk. Because if a claim rests on what someone later came to believe, rather than what they knew at the time, the court must treat that claim differently. Not dismiss it outright, but weigh it differently. And weighting matters. This is where the tone in the courtroom shifted again, subtly, but unmistakably. The lawyers began to slow the process down. They asked fewer questions, but each one went deeper. They weren't trying to catch Harry out. They were trying to understand the architecture of his memory. Where does this recollection originate? How often has it been revisited? In what contexts has it been repeated? These questions might seem abstract, but they have a concrete purpose. The more often a memory is retold, the more it solidifies, not necessarily in accuracy, but in confidence. Psychologists have studied this for decades. Courts are well aware of it. A memory reinforced through repetition can feel more certain than one experienced only once. That doesn't make it more reliable. Sometimes it makes it less so. And Harry's story has been told many times. Publicly, privately, in writing, in conversation. That repetition is understandable. It's also legally relevant. Because when a witness has told a story repeatedly in non-legal settings, courts must consider how that repetition may have shaped the witness's current testimony. Not to accuse them of fabrication, but to account for influence. This is where the word risk begins to matter. Not guilt, not wrongdoing. Risk. Legal risk arises when testimony creates uncertainty about its own foundations. And that risk doesn't require a smoking gun. It only requires doubt. Doubt about timing, doubt about sourcing, doubt about certainty. This is the kind of doubt that doesn't explode. It accumulates. As the session continued, Harry was asked about specific instances where private information appeared in the press. In some cases, he could recall details vividly. In others, he described a general sense of intrusion rather than a specific memory. That distinction matters. Vivid recall suggests direct experience. Generalized recall suggests pattern recognition. Pattern recognition is powerful in storytelling. It is weaker in court, because courts don't establish a legality through atmosphere. They establish it through action. At one point, Harry conceded that in some cases, his belief that information had been obtained illegally was based on the improbability of journalists knowing certain details through legitimate means. That's a reasonable inference. It's also an inference. And in legal terms, inference requires support. This is where the danger deepened. Because once a court identifies that key elements of a claim rely on inference rather than evidence, it begins to ask whether those inferences were reasonable at the time they were made, or whether they were shaped by later developments. That temporal distinction is crucial. If an inference was reasonable based on information available at the time, it may carry weight. If it was formed later and projected backward, its weight diminishes. And Harry's testimony suggested a mix of both. Again, not a failure, not a lie, but a complexity. Complexity is the enemy of clean verdicts. And it's also the enemy of simple narratives. This is where observers began to sense that the case was drifting away from its original moral clarity. Not because the press was suddenly vindicated, not because Harry was suddenly discredited, but because the story had become harder to tell cleanly. And when stories become hard to tell, institutions get nervous. The monarchy, in particular, is built on narrative discipline. Over centuries, it has survived not by being perfect, but by being consistent. By maintaining a stable relationship between what is said publicly and what can be defended privately. That stability was being tested, not by accusation, but by ambiguity. Ambiguity about what was known when. Ambiguity about how certainty was formed. Ambiguity about how memory evolved. Those ambiguities don't stay confined to a single witness. They raise broader questions. If a senior royal's testimony reveals that parts of his public narrative were shaped by later reinterpretation, what does that mean for how the institution manages truth? Again, not moral truth. Legal truth. The kind of truth that holds up under cross-examination. This is where the emotional contrast became most striking. Harry spoke earnestly, thoughtfully. He didn't appear evasive. If anything, he appeared increasingly aware of the stakes. Not just for his case, but for how his words might be understood. That awareness showed in his pauses, in his corrections, in his willingness to qualify. Those are admirable qualities in a person. They are complicated qualities in a witness. Because qualification introduces space, and space invites challenge. This is where some viewers might ask, isn't this how testimony is supposed to work? Isn't it good that a witness is careful? Yes, absolutely. But the law doesn't reward care in the abstract. It rewards clarity, and clarity was becoming harder to achieve. The judge remained composed, observant, non-reactive. Judges often let these dynamics play out without interruption, allowing patterns to emerge organically. And patterns were emerging, not of deceit, but of reconstruction. A story told with confidence in public was being retold with caution in court. That difference is understandable. It is also consequential. Because courts must decide which version carries more weight. And the answer is almost always the one given under oath. Which raises an uncomfortable implication. If the sworn version is more tentative, more qualified, more uncertain, what does that say about the earlier certainty? Again, not that it was false, but that it may have been overstated. And overstatement, in legal contexts, has consequences. Not necessarily criminal, not necessarily punitive, but strategic. Because once a witness's certainty is softened, opposing counsel adjusts. They don't attack head-on. They probe around the edges. They let the witness's own words do the work. This is what was happening here. The defense didn't need to argue that Harry was wrong. They needed to show that his knowledge was incomplete. And incompleteness weakens claims that rely on intent or method. This is where the phrase legal exposure begins to circulate quietly. Not exposure to punishment. Exposure to challenge. Exposure to reinterpretation. Exposure to risk beyond the immediate case. Because when sworn testimony introduces ambiguity, it doesn't just affect the current proceedings. It creates a record, and records can be revisited. They can be cited. They can be compared. They can be used. That's when advisors start thinking ahead. Not about this week, not about headlines, but about what happens if this record intersects with something else. Another case, another inquiry, another dispute. Because once something is on the record, it doesn't belong to the witness anymore. It belongs to anyone who needs it. This is the moment where the stakes quietly rose. Not because Harry was in trouble, but because the situation had become unpredictable. Predictability is comfort in legal systems. Unpredictability is risk, and risk triggers preparation. The courtroom session ended without resolution. No verdict, no ruling, just an adjournment. But the conversations that followed were different, more subdued, more analytical. People weren't asking, who's winning? They were asking, where is this going? And that's a very different question. Because once memory becomes a legal risk, the case stops being about the past. It becomes about the future. What future arguments might be enabled by this testimony? What future challenges might arise? What future decisions might need to be made, not by Harry, but by those connected to him? Those questions don't get answered in courtrooms. They get answered in meetings, behind closed doors, without transcripts, without microphones. And the answers to those questions often shape what happens next far more than anything said under oath. The next chapter of this story would not be driven by memory at all. It would be driven by reaction. Because once the record reveals uncertainty, institutions respond, not to punish, but to protect. And that response was already beginning to take shape. What came next would not unfold in the witness box. It would unfold in silence. There are moments in court that never make it into transcripts. They aren't spoken. They aren't ruled on. They aren't quoted. But they matter. Because while the official record captures words, it does not capture reactions. It doesn't record who stopped writing. It doesn't note who leaned back. It doesn't preserve the silence that falls when everyone realizes the direction has changed. And this was one of those moments. It happened not during a question, but immediately after an answer. A small one. Almost forgettable if you weren't paying attention. Prince Harry had just clarified, again, that certain beliefs he once held with confidence were shaped over time. That his understanding of how information may have been obtained evolved as more details emerged in unrelated cases. That his certainty, in hindsight, had solidified later than the events themselves. There was nothing explosive about the statement, but the room reacted anyway. Not with noise, with stillness. One of the lawyers stopped flipping pages. A journalist paused mid-keystroke. Even the judge looked up, not sharply, not skeptically, just long enough to register what had been said. That's the kind of reaction that doesn't get reported. But it's the kind that tells you something important has just landed. Because courtrooms are built for repetition, lawyers hear hundreds of answers that blur together. When something interrupts that rhythm, it's rarely accidental. What interrupted it here wasn't a contradiction, not explicitly. It was implication. The implication that a portion of Harry's long-standing public narrative was not anchored in contemporaneous knowledge, but in retrospective understanding. Again, not wrongdoing, but recalibration. And recalibration forces reassessment. The lawyers didn't capitalize on the moment. They didn't seize it. They didn't escalate. That restraint was telling. Because experienced counsel knows when a point doesn't need emphasis. If something is strong enough, you let it sit. And they did. As proceedings continued, there was a subtle shift in posture around the room. Less leaning forward. More stillness. The energy flattened, not in boredom, but in concentration. This wasn't theater anymore. This was evaluation. Legal observers sitting quietly along the back wall exchanged brief looks, the kind that don't signal shock, but recognition. Because what they were watching was not a witness unraveling. It was something more nuanced. They were watching a case shed its certainty. And when certainty drains from a case, gravity changes. The questions that followed were less frequent, but more targeted. Each one seemed designed not to provoke, but to delineate. What exactly do you remember from that period? What exactly did you know at the time? What conclusions did you draw later? Those questions weren't aggressive. They were diagnostic. And diagnostics are dangerous because they don't argue. They classify. As Harry answered, the classification became clearer. Some experiences were direct. Some were inferred. Some were assumed. Some were later confirmed elsewhere and projected backward. That mix doesn't invalidate a claim, but it complicates it. And complication is kryptonite to clean legal narratives. This is where something else became noticeable. Harry began to speak more slowly, not because he was struggling, but because he was choosing words more deliberately. You could see him considering how a sentence might sound not just now, but later. Later in the case. Later in the media. Later in a judgment. That kind of awareness is not a sign of guilt. It's a sign of understanding stakes. But it also reveals something else. It reveals that the witness knows the margin for error has narrowed. And when that happens, every word becomes heavier. The courtroom felt it. Even without commentary, you could sense that this was no longer just a legal contest between a claimant and a publisher. It had become something closer to an audit, of memory, of narrative, of credibility. Audits don't accuse. They measure. And measurement is uncomfortable. At one point, during a short pause between questions, the silence stretched just a second longer than usual. No one rushed to fill it. No one coughed. No papers shuffled. That's not normal courtroom behavior. Courtrooms are noisy places, even quiet ones. There's always movement. Always sound. When that sound stops, it means people are thinking. And when lawyers stop thinking about what to say next and start thinking about what they've already heard, something has shifted. Outside the courtroom, the press coverage remained relatively unchanged. Headlines still framed the case as a battle between Harry and the tabloids. Commentators still debated press ethics. The larger narrative hadn't caught up yet. But inside, the focus was drifting. This was no longer about proving that wrongdoing occurred. It was about whether the claimant's understanding of that wrongdoing was sufficiently grounded at the time it was asserted. That distinction might seem academic. It isn't. Because courts don't just decide what happened. They decide what can be relied upon. And reliability is about more than sincerity. As the session wore on, the lawyers subtly adjusted their approach. They stopped circling the same themes. They began to test boundaries. Not boundaries of fact, boundaries of assertion. They weren't asking, did this happen? They were asking, could you have known this then? That question changes everything. Because if the answer is no, the court has to consider how.